Good evening, everyone. Chapter 2 of Title 5 talks about what is included in civil liability. So remember, Article 100 is our basis that every person criminally liable is also civilly liable. And please take note on those instances or classification wherein despite the acquittal of the accused, he could still be made civilly liable. So what is included in civil liability as provided under Article 104? So it includes restitution, reparation of the damage caused, and indemnification for consequential damages. To illustrate the three so that you can at least understand the difference between the three terms, when we say restitution, to illustrate this one would be in a case of theft, for example. So when we talk of restitution, we are referring to the return of the property subject of the thievery. We have to return the very same object that was taken from the private offended party. Now, there are also instances where the return of the very thing itself, which is the object of the thievery, cannot be returned. For example, so what would be the civil liability now of the offender? You have there the next one, you have the reparation. And when we say reparation, this is available in cases where the return of the property stolen is not possible. The culprit must pay the value of the property stolen that is for theft. And in cases of physical injuries, the reparation of the damage caused would consist in the payment of hospital bills, the doctor's fees to the offended party. And the last one would be indemnification for consequential damages. So in the example we have given, especially on physical injury, the consequential damages would include loss of the salary or loss of earnings on the part of the offended party because of the offense committed against him. So the accused will be required to pay for the consequential damages. He has to indemnify the private offended party. I think you can still recall about pecuniary liability. So how do we distinguish pecuniary liability from the civil liability that we have just mentioned? Now, Article 104, which provides for the three forms of civil liability, Article 38, on the other hand, it provides us for the order of payment of pecuniary liabilities, which may be distinguished as follows. Both actually include reparation of the damage caused and indemnification for consequential damages. While civil liabilities include restitution, pecuniary liability do not include restitution because the latter refers to liabilities to be paid out of the property of the offender. In restitution, there is nothing to pay in terms of money because it is the property itself unlawfully taken that has to be returned by the offender to the offended party. Next, pecuniary liability includes fine and cost of the proceeding, while in civil liabilities, it do not include fine and cost of the proceeding. Next question would be, how do we make restitution to the offended party? Now remember, in restitution, you have to return the very thing itself, subject of the unlawful taking in theft. So, under Article 105, it provides that the restitution of the thing itself must be made whenever possible, with allowance for any deterioration or diminution of value as determined by the court. The thing itself shall be restored even though it may be found in the possession of a third person who has acquired it by lawful means, saving to the latter his action against the proper person who may be liable to him. Now take note that the second paragraph gives us a scenario wherein the very thing itself, subject of the thievery, are now in the possession of the third person. And the law provides that that third person acquired it by lawful means. So what would be the effect? Can you recover it from the third person who acquired it by lawful means? The answer is yes. And in fact, you don't need to pay that third person. The remedy of the third person is to go after the person, the other person, to whom he might purchase that particular thing, subject of the unlawful taking. The last paragraph would say that this provision is not applicable in cases in which the thing has been acquired by the third person in the manner and under circumstances under the requirements which by law bar an action for its discovery. The last paragraph would actually tell us that if that acquisition by the innocent buyer, the third person who came into lawful possession of the thing, while in the first paragraph we say earlier that he must give back the property without being reimbursed by the offended party, but his remedy is to go after that person to whom he lawfully acquired the same. But in the last paragraph, if that lawful means to which that third person acquired possession of that property subject of the unlawful taking is through public auction or sale, he can ask for reimbursement. Okay, he can ask for reimbursement. Okay, to illustrate the provision, what if the crime is malversation? Or is Article 105, remember on restitution, is Article 105 properly applied to the forfeiture of the house built with the money malversed by a public officer? Now you have there the case of Garcia versus Between, wherein the High Court applied the provisions of Article 105 to the forfeiture of the house built with the money malversed by a public officer. With allowance of any deterioration or diminution of value, to return the thing, an accused will be ordered to pay such amount representing the deterioration. The general rule is that the owner of the property illegally taken by the offender can recover it from whomsoever is in possession thereof. So, what do we mean by who has acquired it by lawful means? The thing itself shall be restored even though found in the possession of a third person who has acquired it by lawful means. Thus, even if the property stolen was acquired by a third person by purchase, without knowing that it had been stolen, such property shall be returned to the owner. No reimbursement. Okay? No reimbursement. If the thing is acquired by a person who knows it to be stolen, okay, he knows the same to be stolen, what would be the consequence? That person who bought it despite his knowledge that the same is stolen is regarded as an accessory to the crime, and he is criminally liable. He could also be made liable under PD 1612 or the anti-fencing law, and if he is charged under that special law, he is not charged as an accessory but as a principal of PD 1612. Under what circumstance? If he knows that the thing he is buying is a subject of thievery or robbery. So we can take it back from his possession without reimbursement. But if he came into possession in good faith, he did not know of the unlawful origin of the property, he bought it from a public sale or public auction, coupled with good faith, then that third person is entitled to reimbursement. The court which convicted the accused of estafa may summon the owner of the pawn shop, and after hearing him, order the return of the jewels pawned to him without reimbursement of the amount of the pledge. The pawn shop owner may seek his remedy from the person who pawned the jewels, that is Reyes versus Ruiz. May restitution be ordered even if accused is acquitted. In the case of People versus Alejano, the court ruled that restitution may be ordered even if accused is acquitted, provided the offense is proved and it is shown that the thing belongs to somebody else. There is really that proof that it belongs to somebody else. As a rule, if the accused is acquitted, the court should not order the return of the property to its alleged owner. But if it is shown that the ring belonged to and was in possession of somebody else and that it was stolen from him, but the identity of the thief was not established by the prosecution and the accused pawned it in the pawn shop from which it was recovered, the court should order its return to the owner. In this case, the offense was proved, but not the identity of the offender. So you have to remember that in any criminal case, if the subject of the taking belongs to an innocent third party, the court can order for the return of it to its lawful owner. In fact, under certain circumstances, that lawful owner may actually be allowed to, in other instances, either he would file a separate civil action for the recovery of possession, or maybe the court would be so lenient to allow him to intervene in the criminal action, proving that the same is lawfully belonging to him. So in this case of People versus Alejano, wherein the court was able to prove that the same lawfully belongs to this particular person, the court can actually order for the return, and the court did order for the return of the ring to the lawful owner. Is restitution limited only to crimes against property? The general rule, yes. It is limited to crimes against property because remember, in restitution, you have to return the very thing itself, subject of the unlawful taking. So presumably, it refers to crimes against person. But when a crime is not against, crimes against property. But when a crime is not against property, as a rule, restitution or reparation of the thing, no restitution or reparation of the thing can be done because there was no object or property that was stolen. So there would be nothing to return. But in treason, the defendant was ordered to return the 3,900 to the person from whom he took the same when he committed the treasonous act. People versus Logo. In an abduction case, the defendant were ordered to return the 10 pesos taken by the accused from the offended girl. U.S. versus Vanilla. Okay, so these are exceptions. General rule, it is limited to crimes against property. Okay, so that is restitution. Again, how do you make restitution? To return the very thing itself subject of the unlawful taking. Now, how about reparation? Article 106 provides that the court shall determine the amount of damage, taking into consideration the price of the thing whenever possible and its special sentimental value to the injured party, and reparation shall be made accordingly. So the court will order for the reparation in case restitution is not possible. Thus, when the stolen property cannot be returned because it was sold by the thief to an unknown person, he will be required by the court, if found guilty, to pay the actual price of the thing plus its sentimental value to its owner. If there is no evidence as to the value of the thing unrecovered, then in People versus Delena, reparation cannot be made because you will have no basis as to how much would be the reparation if you cannot prove the value, actual value of the thing subject of the unlawful taking. Okay, so to reiterate, restitution, you have to return the very thing itself. Reparation, if restitution is not possible, you will be required to pay for the value plus sentimental value of the thing as far as the offended party is concerned. Okay, so we're done with the two civil liability that the offender may be required to pay to the offended party. Then the last one is indemnification. What includes indemnification? Now take note that what is to be indemnified by the offender are the consequential damages suffered by the offended party. Okay, and take note, it shall not include those damages suffered by the injured party because it may include those damages suffered by his family or by a third person by reason of the crime. So indemnity refers generally to crimes against person, while reparation and restitution refers to crimes against property as a general rule. So let's illustrate. In a physical injuries case, the injured party is entitled to be paid for whatever he spent for the treatment of his wounds, doctor's fees, and for the medicine. And furthermore, his salary or wages unearned by him because of his inability to work due to the injuries received by him, the damages sustained by him because of the loss of a limb or lessening of his earning capacity. What does this mean? That because of the injury he sustained, maybe his limbs would not function, is not functioning well anymore after the commission of the crime. So his earning capacity has lessened. So this has to be proved by the offended party that because of the injury he sustained, he cannot earn this much already. Meaning to say, if before he used to earn 500 as a tricycle driver, but because of the incident wherein the accused injured his legs, for example, and because of that, he cannot drive well his tricycle, so he now earns only 100 from the 400. So through the difference there, it can be claimed as part of the consequential damages. Now, last time I've mentioned about indemnity in case of death, and I've told you na under the law, the law that actually provides for indemnity in case of death is the Civil Code, and the same is pegged at the amount of 3,000. And the Supreme Court has increased it through cases decided by them, and now it is set at 50,000 pesos. But if the death of the victim is qualified, meaning to say it is attended by qualifying aggravating circumstance, the indemnity shall be at 75,000. You also have there loss of earning capacity of the deceased. So we have cases to support that the deceased lost his earning capacity, and you have there to illustrate that one is to have there a UST medical student. He has a promising career ahead of him, but then he died. The accused there was actually required to pay for loss of earning capacity. Support in favor of a person to whom the deceased was obliged to give, such person not being an heir of the deceased. So when we say not being an heir, meaning to say it is not illegitimate child of the deceased. So maybe the deceased has other obligation to a person not his heir. And then moral damages for mental anguish in favor of the spouse, descendants, and ascendants, as well as exemplary damages. So the moral damages there are for the sleepless nights of the spouse, ascendants, and descendants. And then exemplary damages in certain cases, these are granted by the court to set as a precedent to correct a wrong, to prevent others from committing the same crime as the accused did. Now, how about for rape? So the indemnity is also at 50,000. But if the rape is with homicide, the indemnity is 100,000. And then you have the case of People versus Gumimba, wherein the court granted the year's civil indemnity of 100,000 for the death with rape of the victim, moral damages at 75,000, temperate damages at 25, and exemplary damages at 100,000 pesos. Now, we've mentioned earlier about indemnity for the loss of the victim's earning capacity. So how about indemnity for the loss of victim's earning capacity? So to compute the same, you have there the formula. Net earning capacity equals life expectancy times open parentheses gross annual income minus living expenses. Now, as far as life expectancy is concerned, the law is actually adopting the life expectancy based on the American expectancy table of mortality. And they also compute the life expectancy using the formula. The 80 there is constant. That is presumed that the person, the longest that he would live is 80. So 2/3 times 80 less the age of the deceased at the time of his death. So let us presume that the deceased is 50 years old at the time of his death. So 50 minus 80 minus 50 is 30. So 30 times 2, that would make it 60 divided by 3. So 20 years. So the life expectancy is 20. Now you have there the gross annual income. Let us say that the gross annual income of the deceased is 1 million minus living expenses, where the law presumes estimates it to be at 50%. So 1 million minus 500,000 equals 500,000. So if you are going to compute 500,000 times the 20 life expectancy of the deceased, then the loss of earning capacity then shall be at 10 million pesos. Now, next question would be, who has the obligation to make restitution, reparation, or indemnification for consequential damages and actions to demand the same? Now, it actually devolves to the heirs of the person liable, just in case the person liable, let's say, died, for example. And the action to demand restoration, reparation, and indemnification likewise descends to the heirs of the person injured, just in case that offended party died, for example. So to illustrate that one, the heirs of the person liable as a rule has no obligation if restoration is not possible and the deceased left no property. Because while it would, what was the term? While it would devolve upon the heirs, we have to reconcile the fact that the heirs of the deceased offender is not criminally liable, but they have the obligation, just in case the accused deceased is proven to be civilly liable as well to the crime he commits, but what is to answer for that civil liability is the property of the deceased offender. Thus, if A stole a ring, which he later sold to an unknown person, and after A's conviction by final judgment, A died, but he left no property to meet the reparation, A's heirs cannot be made to repair the damage. But if A left property, the heirs may be required to pay out of the proceeds of the property of A. See? So the one that will be used to answer for the civil liability would be the property of the deceased offender. The same thing will be said with respect to indemnification. So as far as the offended, on the other hand, as far as the offended party is concerned, just in case namatay po si offended party, then his heirs has the right to demand the same from the accused if still alive. They can pursue the claim to the estate of the accused in case he left some properties. As a rule, civil liability is possible only when the offender dies after judgment based on delict only. Okay, based on delict. Because if the accused died before final judgment, as a rule, since his death extinguishes his criminal liability, but at the time of his death, he is not yet convicted by final judgment, it follows nga wala sa civil liability. So that's why you have there based on delict only. Why based on delict only? Because remember we have their exceptions. Example, you have there the independent civil action. Okay, if you have their other causes of action to which you can claim and support your cause of action other than the delict itself, like law on the Civil Code of the Philippines, it could be through a contract. Now, just in case there are more than one accused in the commission of the crime, so how do we make them civilly liable? Now, let us say that the court awarded damages to the offended party, but the next question is, how do we make the accused civilly liable just in case there are more than one of them? Because it doesn't mean that if the court awarded 50,000 to the heirs of the deceased victim, the deceased the victim who died, it doesn't mean that the accused would pay 50,000 each to the offended party, because the 50,000 there is awarded to the heirs of the deceased as a whole. So it has to be shared alike, divided by all of the accused. So Article 109 provides that if there are two or more persons civilly liable for a felony, the court shall determine the amount for which each must respond. Example, the court awarded a civil liability of 6,000 to the offended party, and it has to be apportioned as follows. Now, take note that it made mention of principal, it made mention of accomplice. In other words, as far as the civil aspect is concerned, it is also prorated. Remember that the criminal aspect, if they are found guilty beyond reasonable doubt of the crime they commit, the penalties of the principal is higher than that of the accomplice and the accessory. So it follows in the civil aspect, mas gamay sad ang share ni accessory as compared ni mo ni accomplice or ni principal mismo. So principal shall be primarily liable of 3,000, so that is half of the award of the court. And the four accomplices shall be primarily and in solidum among themselves for 3,000. So the four accomplices has to divide the 3,000, so that would make 750 each. Okay, 750 each. Now, what do we mean by in solidum? It is synonymous with solidary liability. In case of insolvency of the accomplices, the principal shall be subsidiarily liable excuse me, for their share of the indemnity, and in case of insolvency of the principal, the accomplices shall be subsidiarily liable jointly and severally from the indemnity due from said principal. So in other words, when we say solidum or solidary liability, if the principal is insolvent, the accomplices shall be subsidiarily liable of the share of the liability of the principal. Same thing with the principal. If the accomplices are insolvent, the principal shall also become subsidiary liable of the share of all the accomplices of 3,000. Now, what would be the remedy? Just in case, let's say that the principal is insolvent, so kinsay gigukod ni offended party, si accessory. Makabayad si accessory, subject of course to the remedy that he can ask for reimbursement to the principal. Same with vice versa. Kung insolvent si accomplice, si principal pwede nimo paninglan sa share ni accessory. Okay? Vice versa. Now, Article 110, several and subsidiary liability of principals, accomplice, and accessories of a felony. You have their preference in payment. Notwithstanding the provision of the next preceding article, the principals, accomplices, and accessories, each within their respective class, shall be liable severally among themselves for their quotas and subsidiaries for those of the other person liable. The subsidiary liability shall be enforced first against the property of the principal, next to that of the accomplices, and last to the accessory. So this is what is referred to in Article 110. You have there preference of payment. So ang ingon, imo sa kunong paninglan sa si principal. So kung insolvent, usa pa ka moagi ni accomplice, o insolvent siya, usa pa pud si accessory. Whenever the liability in solidum or the subsidiary liability has been enforced, the person by whom payment has been made shall have the right of action against the others for the amount of their respective shares. So pwede siya magpa-refund dito, that is his remedy. Illustration. When there are principals and accessories in the commission of the crime of theft of large cattle valued at 200, the principals are solidarily liable for 150, which represents their quota, and subsidiarily liable for 50, representing the quota of the accessory. So that is people versus tukbo. The principal is primarily liable for his own part of the indemnity. As far as the accomplice or the accessory, he shall be subsidiarily liable. And on the part of the accessory or accomplice, they are principally liable of their own share, and they are subsidiarily liable of the share of the principal. Obligation to make restitution in certain cases, Article 111. Any person who has participated gratuitously in the proceeds of a felony shall be bound to make restitution in the amount equivalent to the extent of such participation. Now, when shall Article 111 applicable? Who is this person who participated gratuitously? The person who participated gratuitously is in the proceeds of a felony referred to in this article is not criminally liable. In other words, the law cannot go after him even as an accessory. Meaning to say, wala gyud tay cause of action against him. We really cannot make him criminally liable. That's why, but he has participation, but the law says is not criminally liable. So he is not charged as an accessory. It's because we cannot prove him to be an accessory. So what would be, so under this particular set of facts, Article 111 applies. When can we make him when can we make him obliged to make restitution? Now, if that person who participated gratuitously in the proceeds of the felony, remember, if he knew that the property came from an illegal source, he is an accessory. And he is not only civilly liable, but also criminally liable. But here, he is not really an accessory. Hence, we cannot make him criminally liable, but we can only make him civilly liable to make restitution. And when and the law further requires that this person who participated gratuitously there must be increase of his wealth or fortune because of his gratuitous participation. Because if there is no increase in his wealth or participation, then he is also not required to make restitution. So, sa tinamban pa, kani nga person gi-refer ni 111, he received it for free. Okay, he received it for free. And if with a fee, if nanay fee involved, go back to Article 105. But remember, this person here is not criminally liable. To illustrate, A, after stealing a diamond ring worth 1,000, gave it to B, who, not knowing the illegal origin of the same, accepts it. Later, B sells the ring for 500 to a foreigner, who immediately leaves the country. As the ring cannot be returned, the remedy available to the offended party is to obtain from the offender the reparation of the value of the ring. In case A is insolvent, B shall be subsidiarily liable in the sum not exceeding 500, which is the gratuitous share in the commission of the crime. So if you notice here, this person referred to in Article 111 can only be made to restitute if the offender in the criminal case is insolvent. He will be subsidiarily liable in cases of insolvency of the offender in the criminal case. The fortune of the innocent person must be augmented by his participation in the process of the crime. That is what I'm telling you earlier. Is it necessary? It is necessary that his fortune has been augmented by his participation in the process of the crime. If he merely participated in the eating of the stolen property, so he is not obligated to make restitution because his fortune was not enhanced thereby. Okay, so that ends chapter 2. So let's have chapter 3, extension and survival of civil liability. How is civil liability extinguished? In the previous lessons that we have, we've learned about how is criminal liability extinguished. This time, we are talking about how is civil liability extinguished. So Article 112 provides that civil liability established in Articles 100 to 103 shall be extinguished in the same manner as obligations in accordance with the provisions of the Civil Code. Okay, so we will refer to the provisions of the Civil Code as far as extension of civil liability is concerned. And as far as the civil law is concerned, it has actually modes of extinction of civil liability, such as by payment or performance. In other words, if you are there being ordered by the court to pay this amount as damages, if you pay, the civil liability is extinguished. Or if the civil damages, if the damages requires you to perform something, it is extinguished by your performance. You also have their loss of the thing due, because by the loss of the thing due, there is nothing to restitute anymore. That's why reparation came in. You also have their condonation or remission of the debt, meaning to say the offended party waives his right to the civil liability. And you also have their confusion or merger of the rights of the creditor and debtor, meaning to say, while you are the creditor before, by under sheer of chance, ikaw na po nautangan, so mahug na nga na-fused or na-merge na inyong rights. You also have there by compensation. By compensation, we would mean there was in exchange of something, of the property was stolen, so that is compensation. Novation is change in the conditions. For example, so there is change of the principal liability of the accused. Other causes such as annulment or rescission of the contract, fulfillment of a resolutory condition, for example, if there is, and prescription. In other words, if the criminal aspect if the crime has prescribed, then you cannot actually make also him civilly liable if the crime has prescribed. Obligation to satisfy civil liability. Except in case of extinction of civil liability as provided in the next preceding article, the offender shall continue to be obliged to satisfy the civil liability resulting from the crime committed by him, notwithstanding the fact that he has served his sentence, consisting of deprivation of liberty or other rights, or has not been required to serve the same by reason of amnesty, pardon, commutation of sentence, or any other reason. What do we simply mean by Article 113? That despite the extinction of the criminal liability, civil liability survives. And that even includes even if accused was granted probation, because probation was not mentioned here. So this amnesty, pardon, commutation, they are referring to the criminal aspect. Same with probation. Civil liability survives. Okay, let me end the semester by saying good luck and may God bless you and guide you as you achieve your dreams of becoming lawyer. And thank you for the wonderful semester that we have been sharing, and I wish you well. Good luck to your dreams and see you soon. Thank you.